Hello, good afternoon. Welcome to The Law. This is your legal light. It is your health law. I'm Samson Ladi Anyanini. I hope that you have enjoyed yourself in the last 11 months when we brought the law live to your homes by way of a quiz competition, the Law Challenge Ghana, with the 10 law schools across the country and the universities showing us their legal prowess. I trust that in the process, you learned some good law. Now, we switch back to your health law in a manner that you can directly get some help. Now, today, what are we looking at? Decriminalizing petty offenses. Did you know that homelessness and begging could get you paying 1,800 and or 3 months in jail? There must be other effective ways of dealing with such petty crimes. Some people are in jail for getting drunk and quarrelsome. Note that, for getting drunk and quarrelsome, they are in jail. Yes, because that is an offense, attracting up to 3 years in jail. Some are crammed in those prisons to starve for the offense of making a loud noise, singing a profane song. Did you know that? Singing a profane song, or an indecent and obscene or abusive song, or for displaying insulting inscription or an object which is meant to annoy or irritate someone. Did you know about that? Or for using abusive words. But when they were presented before the court, they were unable to afford 120 cedis as a fine. A total of 38,589 people were convicted within 5 years, 2015 to 2020. 31,018, that is 80.3% of this total, are youth aged 18 to 35. We do not know exactly how many got into prison over petty offenses, or call them poverty offenses. But could decriminalization of these petty or poverty offenses and a regime of non-custodial sentencing, asking you to do some work, communal labor of sorts, reduce the prison numbers and avoid the danger that some of the youth who go into prison and return pose to society? As we know, while in prison, the harsh life there predisposes them to criminal conduct. This is what is engaging us this morning, and I have the best to help us look at them. Welcome once again to The Law. This is your legal light. It is your health law. I'm Samson Ladi Anyanini. We'll be right back. You're welcome back. Now, you can join us as always and let us know what you think about what we are discussing, what can be done. Decriminalizing petty offenses. And my guest this morning, Dr. Isidore Tofor, is head of law department, GIMPA, criminal law lecturer. He is a researcher. Doc, thank you very much for making time to join us. Right, you will have to unmute your mic.
My mic is unmuted.
Great, we can hear you now. Thank you very much. I know that you had been very busy and you had a number of things to attend to, but again, thanks to me.
All right. I'm happy to be here.
All right. Also, Edmund Amakai Foley. Edmund Amakai Foley is Director of Programs, Institute for Human Rights and Development in Africa. Edmund, thank you so very much for joining us.
Thank you very much, Samson. Good afternoon. And catching up with my former colleague at GIMPA,
right.
Dr. Tufo. Good to see you.
Great.
Yeah, good to see you.
I'm happy to provide a platform for reunion for the two of you, particularly because of you, Edmund. You are globetrotting all over the place. All right. We'll be joined shortly right here in the studio by Mina Mensah. She's Director, Africa Office, Commonwealth Human Rights Initiative. They have also been actually pioneering a project for a while now on decriminalizing petty offenses. So let's begin with Dr. Isidore Tufo. Why is this an important thing to talk about in the first place?
Good. First of all, greetings to the audience. Let me say that when we talk about the criminal justice system, that is, first of all, the most powerful tool in the hands of the state as far as controlling human behavior is concerned. So criminalization and decriminalization are always going to be the two key things that we need to address as far as determining the level of acceptable prohibitions is concerned. We have a number of criminal offenses on our statute books, Act 29, and so many other statutes. And I must say that beginning from 1892, when we had, let's say, the skeletal draft that has gone through all the draft till today, there are many offenses that have been captured that have outlived their usefulness. There are some that have come added up to the existing ones that you really do not need to be on the statute books. There are some conduct that have been prohibited and that do not deserve to be prohibited. So as society evolves, we have new things coming up. We have human rights, we have rule of law, there are many things coming up. So the time always comes where there is the need to prune our laws and basically to get rid of all those that do not serve the interest of society. That's the main reason why it's always important to talk about that.
Right. So I will come back to you shortly. So we look at the set of conduct that has been criminalized that we refer to when we talk about petty offenses and why they should be decriminalized. Of course, we must also be answering the question, what should replace those if we decriminalize them? So, Edmund, what would you say? Why is this an important topic in the first place?
Thank you, Samson. As Isidore said, definitely the maintenance of law and order is a critical function of the state. But as states have evolved on the African continent and across, the globe, but more pertinent to our circumstances, most African countries, you would say, are still in the process of nation building. And we have also been thrust onto a global scene where increasingly we are seeing economic development being linked to our legal and political development. And so the question of decriminalization of petty offenses or taking a second look at our criminal justice systems has come up strongly because we are seeing that crime is no longer just a matter of punishing people, but a question of life and death. Many of the people who are being caught in committing crime are doing so mostly because of poverty. We are seeing as our economic circumstances become more and more difficult for the ordinary man, people are committing crime not just as social deviants, but simply because they are too poor to take care of themselves. Hence, the discussion has really emerged, at least over the last decade, within the African human rights system. And by that, I refer to at least the AU space, drawing lessons from the Scandinavian countries and other advanced economies where they are taking a second look at crime and how we deal with it. It's also a cost issue, how much we are spending on incarcerating people or keeping them in custody at the expense of the state. Therefore, why don't we start looking at certain offenses which may not necessarily offend the generality of the population, but which are very individual in nature, and find other ways of reforming that individual without so much of a social cost to the entire body public.
I realized that reading around it, particularly with some documentation and research by the Commonwealth Human Rights Initiative, they point us to what the African Charter says about petty offenses. For example, it says that petty offenses are inconsistent with Articles 3, 2, 3, and 18 of the African Charter on the right to equality and non-discrimination. How do we justify that? Yes, starting with Dr. Isidore Tufo.
Good. So looking at the scope, first of all, we need to have in mind what we mean by petty offenses, something that is not defined because of the classifications of offenses that we have. Basically, three main categories of offenses: misdemeanors, first-degree felonies, second-degree felonies. Of course, we can add capital offenses also. But we do not, first of all, know what petty offenses are. But as far as the international human rights regime is concerned, reference here is made to such conduct that are criminalized, that intend to violate the right of the individual, especially the poor. And that's why we have these international instruments being referred to, where we're looking at certain types of offenses that seem to target a particular group of people, or let's say we have a particular group of people who will usually fall foul of such laws simply because they are poor. That's why we have these references to international human rights instruments and provisions.
The African leaders, as they discuss this issue, and I want us to take it from there before we come locally, also feel that insist that petty offenses are inconsistent with Article 5 of the African Charter on the right to dignity and freedom from torture, cruel, inhuman, or degrading punishment and treatment. Of course, this is also found in our Constitution. Edmund, how do you explain this?
Yes, thank you, Samson. Human dignity is, well, one of the rights you cannot touch, as it were, like in freedom of movement, but it has been described as fundamental to the very existence of the human being. The South African Constitutional Court, in the famous State versus Makwanyane case, when the death penalty was being struck down in the South African constitutional context, the Constitutional Court really harped on the idea that human dignity goes to the very core of who we are. Now, if you look at the nature and the way in which arrests are done, or the criminal justice system, starting right from arrest, treats persons who commit petty offenses, you find out that they often detract from the very dignity of the human being. A quick example is prostitution. The ECOWAS court recently, in a case involving some women in Nigeria, Dorothy Njamanze versus the Republic of Nigeria, the situation where you have women taking a stroll, are picked up, accused of prostitution, are paraded on TV or at a police station with the suspicion that they are engaging in prostitution or are soliciting. To expose people like that, to have them being subject to public ridicule or even judgment with no basis whatsoever, knowing what their character is. It is on this basis that the African Court, and of course the other policy organs of the African Union, as you are alluding to, have come to the conclusion that yes, it detracts from the very self of a person couched in the terms of the right to human dignity. And then, of course, also disproportionately targets certain people. Look at those who we call rogue or vagabond, or persons who engage in idle or disorderly conduct, persons living on the street. There is no way somebody living in Sakumono or Trasaco Valley or East Legon, or in Shiaesu in Kumasi, is going to find him or herself being picked up from the street. So you find a certain profiling of certain citizens who would invariably always find themselves at the mercy of the justice system, being subject to being picked up for suspicion of having committed these offenses or actually committed these offenses. Just being in the wrong place at the wrong time can get you into prison.
All right. Okay, so like I just mentioned a while ago, Mina Mensah, Director, Africa Office, Commonwealth Human Rights Initiative, joins us in studio. Thank you so very much.
Thank you, Samson, for having me.
And I have been speaking to Dr. Isidore Tuffour, Head of Law Department, GIMPA, Criminal Law Lecturer and Researcher. Edmund Foley is Director of Programs, Institute for Human Rights and Development in Africa. So maybe we take off from where Edmund concluded. For example, I've been reading the Beggars and Destitutes Act. That is a Ghanaian law. And the Beggars and Destitute Act, Section 2, talks about begging as an offense. Begging as an offense. And says a police officer may arrest without a warrant a person who is found begging, a person who is wandering. So if you are found wandering around, a couple of questions could be asked you. And if it is determined that you are not begging because of religious alms, then you could be arrested. If you are a destitute also, and you are asked and you can't give good explanations as to why you are wandering around, you could also be arrested, and you are looking to pay 1,800 maximum as a fine or go to prison for 3 months. What is this thing about petty offenses, and why is it so important to particularly the Commonwealth Human Rights Initiative?
Thank you, Samson. Hello, Doc. How, Edmund? How are you? How is the Gambia treating you anyway? And let me get to the point.
32 degrees.
Oh, wow. Samson, I'll start with the question. Because when you were mentioning, we were talking about the fine in the first place, I smiled. If the man had, or the woman had that kind of money, would the person be on the streets in the first place? But you see, the fundamental question we need to ask ourselves is, what is the purpose of these laws? What is their purpose? And their enforcement. What is the purpose? Why did we put these laws in place? And how is their enforcement like? And how does it contribute to making society safer? And what is the evidence that if somebody begs on the street, the person is making the street unsafe? Unsafe how? And that is one of the reasons why the Commonwealth Human Rights Initiative, we are at the forefront of this advocacy in Ghana. It's a regional advocacy. I must say it's a global advocacy. But we were supported by the Open Society Foundation for West Africa, which has now been subsumed as an OSF Africa, to do some work around that. And we have a lot of laws in our books that are redundant. And some of them also need to be, if we can't even decriminalize them, we need to reclassify them. And so for us, our view is that if you look at the ICCPR, for instance, and you look at the African Charter, they set up an argument that these laws, petty offenses, what are petty offenses? Minor offenses for which you might be fined or given a term. Normally they fine you, in Ghana they fine you. And so the courts themselves are saying that it is not a huge problem. You have committed an offense. And because society, if you encourage deviant behavior, it does not augur well for society. So you need to do some kind of punishment. It's supposed to be a deterrent. So that is why the court will not automatically jail you, but will fine you. But we found out that a lot of these laws are targeted at the poor. Not deliberately, but by their nature, it's normally the poor that you find doing some of these things. It's only a poor person who go on the street to beg. And sometimes for people who even sell in places that they are not supposed to sell, for people who loiter around, you would hardly find somebody who has money just walking around. You go to a recreational center.
We have seen city authorities recently where you have the task force whipping this old woman or, fairly, elderly woman, whipping her because she's selling perhaps at a place that they do not agree. But they are trying to make the city clean. And if this person, that's where they make their living, and we want a clean city, and they are breaching the law, they ought to be punished.
I can understand that, but you see, that is a life-sustaining activity. I always say that the state tends to punish its citizens when the state is not doing what it ought to do in the first place. Because if the structures were in place, people will not go out there to sell. Unfortunately, the structures are not there. We do not have social structures in this country. Our markets are not properly set out. They are congested. So people would do that. So when the state is not taking care of its responsibilities, the easy way is to make the citizens pay. Because like I said, let's go back to the question. What is the purpose for these laws and their enforcement? And then how does it contribute to making society safer? Are you saying that if the environment, we are not saying that we should encourage uncleanness, but does it make the society unsafe? Those are the questions that we need to ask. And we are saying that for some of these things, because they have been criminalized, you give the power to law enforcement agencies, not only police officers, but anybody who has the authority to arrest these people. It is not only the arrest which is the problem. If it is what the person has to go through. You were talking about somebody being whipped. It doesn't end there. The person will be arrested. The goods that the person does not even have money to buy would be seized. The person might necessarily have to pay a bribe. If the person is going to be prosecuted, would have to go through this unfriendly justice system. The state will spend money prosecuting somebody who is selling probably oranges of 100 Ghana cedis. For crying out aloud. Don't we have anything to do with our time and money? These are the things that we need to assess.
And eventually, if they are convicted and sentenced to pay the fine,
they can't pay.
They can't afford it.
Exactly.
So we take them to prison.
And then we use our resources to feed the same person. The same person comes out probably worse off because the person went in as a minor criminal, but probably goes in there and learns a few things that he or she is not supposed to learn, comes out, and because society...
And for each day being in prison, you are fed on less than 2 cedis.
A day, which...
1 cedi, 80 pesos.
And the person comes out, and because society itself, we are so averse to having people who have gone to jail around us, we victimize them. They might not find a job to do, and then we add to the problem. That is why we are saying that it has a ripple effect. Incarcerating or arresting petty offenders has a ripple effect.
I will return to you to ask what exactly ought to be done. What is this advocacy geared to? What should be done? Dr. Tufo, so the range of offenses, for example, that I was referring to in what you had already referred to as our Criminal Offences Act, it talks about offenses such as making a loud noise, singing a profane song, indecent song, obscene song, abusive song, displaying insulting inscriptions or objects to annoy or irritate someone, or using abusive words. And when they are fined 120 and they are not able to pay, then they go to jail. Give us an idea of the range of such offenses that you can clearly say are petty offenses, and what is the justification for suggesting that they should be decriminalized?
So, the list, basically, you have touched on some of them. You realize that these are offenses that, even if they were useful at the time they were made, today they have no justification being on our statute books. What do we seek to achieve by punishing a group of people who meet in the house to drum, let's say maybe a rehearsal group because they do not have a license from a district assembly? That is not justified anywhere. If we're talking about people who are making loud noise, punishing them, you realize that these are, we need to know, first of all, the policy that led to the criminalization of these acts at the time. Even if they were justified, today they are no longer justified. And that's why we need them off our statute books. So I'll always talk about two categories of offenses. We have one group of offenses like the drumming, making noise, for example, beggars, begging and all that. These are offenses that, to me, ought to categorically be off our statute books. So they should be repealed. Not even, I will not even use the word decriminalize. They have to be repealed because criminalizing them does not make any sense anymore. And when we're talking about criminalization, to me, that's where everything begins from. What is criminalization? We need to understand exactly why a particular conduct will move from something acceptable to something that is no longer acceptable. We have processes, in terms of criminalization. And at any point in time, every state should be in a position to justify why a particular conduct has been criminalized. First of all, as Mina was saying, what is it that you're trying to achieve by having that law? What you want to call it an offensive conduct? What is its harm on the society?
For example, the one against getting drunk and being quarrelsome, singing profane songs. We want all of that so that we keep our society sane. Is that not the reason?
That could be the reason. So when it comes to being drunk, this is not an offense that I will automatically say that we have to decriminalize. I will think about, addressing that law in terms of what it's seeking to achieve. Because here it is not the fact of being drunk that is criminalized, but the violent conduct of that habitual drunkard, which may be harmful to society. Because once it is decriminalized, then it means that you can get drunk, get on the street and be violent. So to the extent that you have any possibility of having someone be harmed, then it means something has to be done. And again, you want to also find out, is it a conduct that we should leave the individual victim to seek redress, or it is something that the state should basically control so that we are all safe in society? So this is a balance that you need to play very well. But at the end of the day, this is what you do once you have identified the social harm that this law is trying to deal with. The second question is, do you resolve that by criminalization, or do we have some other alternatives to dealing with the issue? And that is where, again, we need to take, step to think through, find out whether we can go some other way otherwise than criminalization. And then once we decide that no, alternatives are not working, it is criminalization that we need, then we find out what should be the punishment to be meted out to the person. Should it be imprisonment, or we should think outside of the box, especially talking about community service or other things that will not necessarily put the person in prison, or getting the person to pay a fine when the person is poor. Right. So we need to think through all these things, yes.
Yeah, and Edmund, I want us to continue because I want our audiences to have a certain idea of some of the things we are talking about. So aside getting drunk and being quarrelsome, making loud noises, singing a profane song, in this day and time, there will be an argument as to what constitutes a profane song. Singing an indecent song, obscene, abusive song, displaying insulting inscription or object to annoy or irritate someone, or using abusive words. Don't you agree that our society, particularly the African society, is set up such that these things are not acceptable? So if they are criminalized, what's wrong?
And in fact, I would add on to the list. I'm sure people may not know that behaving in a disorderly manner around the burial of a person during a funeral, and in criminal law class, I would tell the students, if you cry, you could be committing a criminal offense. Now, just a quick, one sentence history lesson.
So,
let's
Edmund,
note that
I can't help it. I can hear in the background my production people. They are laughing at example you gave about the disorderly conduct over at a funeral.
Yes. Yes,
Okay.
it's there in section 296, I believe, of our Criminal Offences Act.
Right.
But where did these come from? If you see these things like playing a drum provocatively, in our traditional criminal justice system, these were considered to be serious offenses. Because, of course, depending on which deity or charm you follow, these could have certain implications at custom. And that's what Isidore said. We have long since moved away. The ones around, for instance, begging, disorderly conduct, actually came from the colonial authorities. If you look at paragraph 59 of the African Court's advisory opinion on the compatibility of petty offenses with human rights in Africa, and this is our own African court saying this, the court noted that, firstly, if you took, for instance, begging and idling and vagrancy, which is just walking about, these were brought in to actually first ensure that landowners, and by extension, colonial landowners, had undesirable people off their lands and who could be then available for cheap labor. Secondly, the colonial administration, of course, then wanted to also reduce the cost of caring for the poor. So throw these people into prison or into places where you think they'll rot away. Sadly, the post-colonial African state has continued this. And we ask ourselves, is this consonant with our own African beliefs? I live here in the Gambia. The Gambia is one of Africa's poorest countries. In spite of our challenges and our difficulties, we have beggars. But hardly would you see homeless people in the Gambia. At nightfall, everybody has a place to go and lay their heads because of the strength of the family system. This country has a very strong familial connection where it's quite rare to see somebody sleeping on the street. Everybody will go home. So we must begin to, in correcting these wrongs, look deeply at our African society. There are certain good things about us. We shouldn't think that everything African is bad. In fact, we were the ones who had strong social protection systems that reduced the incidence of such crimes. And so looking forward, yes, we might not punish people, and it wouldn't make sense for crying at a funeral when they are expressing their concern. But on the question of profanity, we have our Apo festival for the people in the Bono areas. It was not just, of course, to spew out profanity. It was a form of civil, I would say, yes, civic expression of the freedom of expression to speak against the ills of the governing authority. So we should carefully, and for all of us, Mina, Isidore, all those of us who have worked in this space, we are not saying by any stretch of imagination that do away with crime in our society. We are calling for a very reasoned, level-headed approach to reconsidering what we call crimes and how we address various categories of crimes in our justice system, rather than the blanket prison that we've adopted from colonial days.
Okay. For the benefit of our audience, when Edmund was reading out some of the things, I think some of you still are in doubt as to whether, in fact, what he's talking about exists in the law. So the section 296, there are some good portions of it, and there are some portions that people have problems with. So let me make an attempt. Section 296, throwing rubbish in the street. Of course, when you are throwing rubbish in the street, that's not good. So it says you could be held liable for that as an offense. And then it talks about unlawfully releasing cattle, that have been impounded, or you are pulling down or damaging or destroying the pond where cattle are lawfully impounded. When you are in a town and you willfully or wantonly, and after being warned to desist, you make a loud or an unseemly noise in a manner that causes or is liable to cause annoyance or disturbance of a person. If you are in a town and without a license in writing from the minister or the local authority, you beat or play a drum, gong, tom-tom, or other similar instrument of music between 8 o'clock at night and 6 in the morning, or you are in a town and you throw or discharge a stone or any other missile in or into a public place, when you are drunk and you are disorderly and you behave in a violent or indecent manner in a prison or a court or a public place, and gets this one too, you behave irreverently or indecently in a church, in a chapel, a mosque, or any other place appropriated for religious worship. So if you entered into a church and you behave irreverently, or entered a mosque and behaved irreverently, you are committing an offense. When he spoke about the funeral, let me read it to you. It says, if you behave irreverently or indecently or insultingly at or near a funeral or in a near public burial ground during the burial of a body, you are also committing an offense. When you are drumming with intent to challenge or insult, you are also committing an offense. My question is, these offenses, they are hardly punished. So what is our problem? How many times have we seen police arresting beggars, arresting, people who are engaged in vagrancy, as in wandering about, aimlessly sleeping rough around the place? The law is against all that. When did we see the police arresting people and throwing them into jail for this?
Samson, yes, you don't see it, but it is in the law. And so if somebody decides to do it, the person is acting in a lawful manner. So that is one of the reasons why we think that some of these things should be completely repealed. Others should be decriminalized. Because if you leave them there, somebody would definitely use it. As a society, our society is deeply steeped in morality. So you can see that some of these laws have moral antecedents and not necessarily criminal antecedents. So it is one of the reasons why someone was, and they are very broad and very vague. What is behaving irreverently in a church? What is that? Or at a religious place? How are you going to describe that? Is it the way the person is dancing?
The pastor is preaching, or the man of God or woman of God is preaching, and then you jump out and maybe you are insulting or saying things. That's irreverent conduct, or?
Oh, really? And how many times does that even happen? You see, as a society, we when it comes to churches and traditional things, people are very careful the way they behave. And in any case, like I said, if the person does that, should the person be arrested and be put in jail? When you look at the Tokyo Principles, it talks about the fact that as much as possible, we arrest and detention should be the last resort. And in cases where we think that a person should be, it's even a crime, maybe you give warnings 1, 2, 3, 4 times, and if the person keeps doing that, then you can arrest. So that is actually declassifying that offense or reclassifying it to remove the criminality out of it. Because at the end of the day, we are talking about prison congestion. And if somebody is arrested for some of these things, automatically the person will be fined if the person is taken to court. But the point is, would it even get there? I can assure you that people get arrested for these things. It just doesn't get to prosecution. At the level of the arresting authorities, some monies may necessarily change hands. And that is one of the reasons why the decriminalization advocacy is going on. Take the criminal aspect out of it. The process of arrest does not happen so that you give certain public officers the leeway to abuse people's rights within the law, because the arrest is within the law. But the person thinks that, okay, if you give me some, there's not really any big harm. So if you give me some 500 cedis or 100 cedis, then we go. So it's the abuse of the process.
In the class of petty offenses, will covered, offenses like wearing your mask and all of those things be classified as petty?
Yes, during the COVID time, one of the, you see, that is why I'm saying that it's in the law. So because it's in the law, there was an ally. That ally was based on what is in the law. It was reactivated. It's not been used for a very long time, but it fits into that. So people were arrested for not wearing masks. People were arrested for breaking lockdowns. People were whipped. Others, money's changed hands. The last one was the one that was really funny. When the police arrested so many people, and they didn't know
what to do with them.
That law, you cannot enforce it. There are quite a number of laws in our books that you can't even enforce it. So what you are doing is you give somebody the power to arrest the offender, and then the person abuses the offender's rights and even collects bribes, corruption. It promotes corruption. So for us, it is important that, like Edmund and Doc said, we sit down and really, really think through the reasons why these things are there. So, and Samson, we are signatories to the African Charter. Ghana is very interested in putting its name or signature on a lot of documents. But when we come back, we do not do the needful to ensure that what we've signed onto, we are putting steps or things or structures in place to ensure that the rights of the citizenry are respected.
Dr. Tufo, what I discover from the African Charter perspective of the discussion is that it doesn't appear their major concern is actually the category of the offense, but the fact of the conditions of our police stations, police cells, and prison cells, where the conditions are so bad, and the possibility of the arresting officers, exercising discretion, that leads to a situation where the dignity of these individuals are violated.
That is correct, because they were trying to link two things together. First of all, you have the poor and those who are unable to afford lawyers or to pay fines, who will therefore have to be at the mercy of the state investigative and prosecutorial agencies. See, we need to talk about certain realities as far as our criminal justice system is concerned. It's not only related to Ghana, but other African countries as well. We have a very abusive system where, beginning from the time of arrest to how a person is charged, a person is taken to court, even during the course of trial, the system abuses right throughout. So for persons who do not have counsel, sometimes you ask yourself whether what is taking place is, first of all, justice. We did the criminal justice, understanding what justice is. You have a number of rights, pre-trial rights, trial rights, post-trial rights, guaranteed under our Constitution. The question is, do we follow them? And as I said at the beginning, when we talk about criminal law, it is the most powerful tool in the hands of the state and its agencies. So when it's given to people who abuse it, then for those who are unable to face them with the law, they become automatically victims. That's why when talking about some of these petty offenses, we have these international agencies trying to tell us that, something, try to look at these protections, and then those who are in charge of applying these laws, who are abusing the system. And because we have the state against its own individuals, who will protect the individuals? No one. Yes, and that's where the problem is. So I think that we need to think through carefully. Of course, when you look at...
So the question to all of you at this point is, so we decriminalize, or as you say, remove these laws and put what in place of them, because we still need to check these conducts in society.
Yeah, good. For me, that's why I said, when you talk about criminalization or decriminalization, it involves a number of principles to apply. First of all, check the social harm that the law seeks to address. Check whether you can only achieve that objective through criminalization, or there are other alternatives. We have not sat down as a country to think about the other alternatives. Even alternatives to imprisonment, for how many years? We are still dragging our feet. Community service is there. So even if if we intend to keep some of these crimes on our statute books, should the individual who is found guilty go to jail for that? Can't we have other alternatives to punishment, to imprisonment? We have so many of them. So for me, what the call that I will make at this point is the need to fasten the process of enacting our community service law. Because once we have many people who will not have their way inside the prisons, just go and do some hours of community service work and you go home. Basically, that is it. Yes.
All right. Okay. Yes, Edmund. The big question people are asking, even after we advertise this subject, was what should we put in place of them? Because we need something in place if we are removing them, or what exactly do you want to be done?
Thank you, Samson. And I think you used the right word, that how do we check social behavior? There are so many other ways apart from criminalization. You see, we also need to, you can incentivize certain behavior. If people would stay away from the street, stay away from begging, we find an incentive, something that makes people want to actually do the right thing. The history of our criminal justice administration, right from, and our own dear Professor Mensah Bonsu has written on this, we seem to be always wanting to criminalize more and more. Look at all the amendments we've done to our Criminal Offences Act. They've all been towards increasing the gravity of offenses or increasing punishments. But sort of the cane is not the only way to get people to behave properly. Sometimes incentivizing would help reduce some of these offenses. Look at police crime statistics in Ghana. The two top crimes are stealing and assault. People are beating each other because, this is to a certain extent out of frustration. How do we, you look at the domestic violence cases and all, people's resilience to even handle each other is weak in the face of so many socioeconomic problems. How do we ensure that we have a better system to help people cope with the difficulties of life? About declassification, we mentioned it somewhere. People are going to jail because stealing is a felony in Ghana, second-degree felony, meaning that you should go to jail for a minimum of 3 years, maximum 10 years. Steal 2 tubers of yam and you are going to sit in prison. So we need to ask ourselves as a country, why should we even continue to spend that 1 cedi, 80 pesos for 3 years? If you add all of that,
what should be done to that person who is stealing the tubers of yam? What should we do to them?
Those 2 tubers of yam, get the person to go sweep the streets or even go and plant the yams back for the owner. Sort of get them to do something more productive than to incarcerate them and spend money on them in prison. Our nation is founded on 2 pillars, freedom and justice. And I have said to both the current AG and of course all his predecessors, what is our national conception of justice? We need to, as Isidore is saying, have a serious discussion as a country. How do we envision justice? And how does that drive our national development? Because that and freedom are the 2 pillars on which our nation is founded. So there are other ways. The cane is not always the way to correct people's behavior. Let's incentivize also where necessary.
But what would be my response to that question? We have heard people, including those in charge of the criminal justice system, say that most of these laws that we are referring to, that we want to them removed from the law or decriminalize, the conduct decriminalized, they are not actually being applied.
Yeah, exactly. In jurisprudence, Professor Mensah Bonsu tells the famous story of the king who would always kill sentries who slept on duty. When they realized it was absurd, for 100 years or so, nobody had been killed. Until one sentry said, well, I slept, kill me. And everybody realized the absurdity in the law. So as Isidore has earlier hinted, and Mina also, let us relook at this 1960 code. And also there are other laws we have. It's not only the Criminal Offences Act, there are other laws, assembly bylaws, which also provide for these petty offenses. Do a proper cleanup, remove them from there, and of course, deal with only the most serious of crimes. Like again, I would emphasize, we are not on this platform saying we shouldn't punish criminal behavior. If need be, let's punish. But we are sitting with a lot of them that don't need, even for punishment, custodial punishment.
All right.
Get the person to do some more productive work to reform as a human being.
Mina, I've listened to you on this subject on a number of times, and there are times when I come to the conclusion that your emphasis is the opportunity for the law enforcer to abuse the law, so that we say, oh, some of them are not being used anyway. But you go to certain towns and villages and even in the cities where some very errant law enforcement, agents, including the police, will abuse people. Like the example we gave about the Accra mayor or the regional minister asking his people to do some work, and they go around whipping people in the name of seeking to enforce sanitation law.
I'll give you one very recent example that CHRI is handling. A taxi driver is driving. He picked a taxi and he's going somewhere. He got to a junction and he didn't see any car coming, so he turns. Before he can say jack, he hears a bang behind his car, and then his car falls into a gutter, and then a policeman falls off a motorbike. So he realized that another motorbike quickly runs off. So I think the policeman was actually chasing an Okada driver. Now this policeman, this driver gets down and sees that people are around. So I think a police patrol car was coming around. The police patrol car came, picked their colleague, sent him to the hospital. The driver ensured that the passengers too, some of them were hit. So, but they were near their houses, so somebody came to pick them to the hospital. And this taxi driver, instead of going to the hospital, goes to the police station, the Dansuman police station. I'm going to name. To the Dansuman police station. He gets arrested, kept in custody for 4 days until CHRI came in. Then back and forth, he was granted bail. He goes to court, and he's told to plead guilty when he goes to court. Now, we had a pro bono lawyer for him. So the case, he was granted bail, and that was the Thursday before Easter in court. The police got annoyed. He's been granted bail. They asked him to plead guilty so that the case ends. He did not. And so when they got back to the police station, his sureties were in court. So ideally, they should have signed for him to get the bail. The police are like, no, we want to go and see the houses of the sureties. They get to Dansuman, and they're like, no, this is Dansuman. Your sureties are from Kasua. So we want sureties in Dansuman.
Oh. Which law is that?
Exactly. Now he finds other taxi drivers in Dansuman who are prepared to act as surety. The police says, it's 3 o'clock, so we will not go to the houses. So it means that he spent the Easter holiday
in
custody. Now he goes to court sometime last week, and then the lawyer was able to get the case dismissed. At the court premise, they want to re-arrest him. They actually re-arrested him, took him back to the police station, granted him bail.
With a new charge?
No, same charge. So these are some of the reasons why, for some offenses, let's take the criminality out. It is the fact that somebody people will use the law. A lot of people do not know their rights. A lot of people do not know the law. So if it's in the law books, and it's interesting, even the charges that they gave, some of them were very funny. I do not know. I'm not a lawyer, but they were absurd. In fact, the lawyer challenged some of them in court, and the judge was like, okay, let them change it. And she was like, no, we are not changing anything here. If they want to change, they should go back. So for these reasons, it is important that we do not give law enforcement agencies the power to even do the arrest for certain offenses so that people's rights are abused. Like Edmund said, it's a process. So all through, or is it Isudo who said that? All through the process, it's so abusive. Even before you are granted bail, the way they'll toss you about, your sureties are sometimes treated like criminals. The witness in this case, she's gone to the police station twice. She's now complaining that instead of giving her a form to go to hospital, the police are refusing to do that. So these are some of the challenges.
Let me get Dr. Tufor to comment briefly on this one by way of giving education to our viewers and listeners. Doc, what will you say to educate people about this? There's arrest, there's a charge, the lawyer goes, the charge is obviously struck out, said the person is discharged, the police rearrest the person again, and even the question of bail, they say they want sureties who live within the area and not, far from the area.
Yes, so unfortunately, this is a situation that we have in this country. The criminal justice system gives a lot of discretion to the agencies that are in charge thereof. So I think that we should have some clear guidelines to govern this process, especially, first of all, what is even arrest? How is arrest conducted in this country? We have Act 30 telling us how it should be done. It is not done. So I'll just talk about the pre-trial process, the pre-trial stage, from the time of arrest to the time the accused person is, let's say, taken to court on arraignment. You realize that this person is 100% in the hands of the police. The person is detained beyond 48 hours. A statement is taken from the person. You are not informed of your right to counsel. All these things have to be complied with. But the thing is that once you jump into the courts, the first thing is about bail and all that. Nobody really questions these police officers as to compliance.
So let's empower our viewers. If you are detained beyond 48 hours, what can you do? Because the law says, the Constitution itself in Article 14 says you should not be detained beyond 48 hours without a court sanctioning it.
Yes. So it becomes a human rights violation when a person is detained beyond 48 hours. Then again, who will have the money to go to court, take a lawyer, go to court, and then fight this case? That's where the problem is, because those who have the money will never be detained beyond 48 hours. It's always about the poor. So you realize that the system is such that the person will have no remedy, whether in a criminal matter or in a civil matter, human rights matter. So that's the first thing. But once you do have detained beyond 48 hours, I will always say that try to get in touch with a lawyer. Now the court has made it very clear that even during weekends and all that, you can apply.
Weekends and holidays.
Yes. So let's people get to know. I think that people need more education. They need to know their rights. Let people get to court, have their right enforced. Let people, especially the right to be informed of the right to counsel. This is something that is always abused. A police officer cannot take a statement from an accused person unless that person has first of all been informed of the right to counsel. And when the person does not have counsel and tells you that I need to talk to someone, but I do not have a lawyer, the state is supposed to provide a lawyer to that accused person or that suspect before the police takes a statement from him.
Thank you very much. I can see where you are taking it now, and we just have run out of time to be able to do so. In some 30 seconds, what would you have to say? Our time is up.
I would want to say that as a people, we need to really think through what we are doing to the criminal justice system. Not only to the offenders, but to the victims and to those who work there as well. To the police, to the judges, to the prison officers.
Right.
We need to think through what our actions at that level.
I can't thank you enough. Mina Mensah, Director, Africa Office, Commonwealth Human Rights Initiative, CHRI. Dr. Isidore Tufor, Head of Law Department, GIMPA, Criminal Law Lecturer and Researcher. Edmund Foley is Director of Programs, Institute for Human Rights and Development in Africa. Thank you all so very much, ladies and gentlemen. And this has been The Law. It is your legal light and your help law. I'm Samson Ladia Yenini. Join us again next week, same time. We will have the opportunity to open the phone lines on the subject we will treat and directly answer your questions and provide you solutions. Have a good afternoon.